A few weeks ago, one of my clients received an email from a US consulate. She had been notified months earlier that the consulate was about to reject her Italian citizenship application. The reason cited was the minor issue. Her great-grandfather had naturalized as a US citizen in the early 30s when her grandfather was still a minor living with him. Under the Ministry's 2024 interpretation, that fact breaks the entire citizenship chain. She had 10 days to respond. Most people in that situation do one of three things. One, they send a short letter saying they disagree. Two, they send nothing at all. Or three, they ask a general practitioner, sometimes not even a lawyer, to draft something quickly. The consulate email she received after I filed the response was different. It said the consulate was suspending the file. They would wait for the Italian Supreme Court to rule on the minor issue before taking any further action. That is not a typical outcome. Most consulates handling identical cases at this exact moment are still issuing final rejections. Through what the memorandum argued, why it was structured the way it was, and what this case tells us about where Italian citizenship recognition stands in 2026. I am Avvocato Michele Vitale. I am an Italian attorney, and in my studio I handle Italian citizenship by descent cases and consular rejection defense. Most of my clients come to me after they have already received a preavviso di rigetto, a pre-rejection notice, and don't know what to do with it. The full case study is linked in the description below. Here is what we are going to cover. 1. What the minor issue is and why it is blocking application in 2026. 2. The specific facts of this case. 3. The 5 arguments in the memorandum and why each one mattered. 4th, the outcome and what it does and does not mean. 5th, what Law 74/2025 changed about the 10-day window going forward. If you're watching this, you probably already know what the minor issue is, but let me give you a clean version, because the framing matters. Italian citizenship by descent, iure sanguinis, or sanguinis, passes through blood. If your Italian ancestor never voluntarily gave up Italian citizenship, the citizenship can in principle flow down to you. The problem arises when a male ancestor naturalized as a foreign citizen when his minor children were still living with him. Article 12 of Italian Law 555 of 1912 has been read by the Ministry of the Interior in a circular issued in October 2024 as providing that those children automatically lost their Italian citizenship along with the naturalizing parent. If that reading is correct, the chain is broken at that point. Every generation below it cannot inherit what was never transmitted. Here is the catch. That reading is disputed. A significant body of case law, including decisions from the Court of Cassation, has rejected it. The question is currently before the Sezioni Unite, the Supreme Court's full civil chamber, and a ruling is expected soon. The oral hearing took place on April 14th, 2026. So, in mid-2026, the Ministry has adopted a restrictive position, a large part of the judiciary has rejected it, and the Supreme Court is about to speak. It is, in other words, an extremely bad time to issue a final administrative rejection in a minor issue case for the consulate, and an extremely important time to file the right response for the applicant. The facts here are common. I see this pattern often. The family chain looked like this. Great-grandfather, Italian by birth, emigrated to the United States, naturalized as a US citizen in the early 30s. Grandfather, born in the United States in the late 1920s, US citizen by birthright. At the time of his father's naturalization, he was a young minor. father born in the United States and the applicant born in the United States. Application filed in 2022. In mid-2026, the consulate issued the preavviso di rigetto, citing the 2024 Ministry Circular. Before we could respond on the substance, we had a procedural problem to address. The consulate had not attached the full text of the notice. It had merely informed the applicant that the notice existed and directed her to retrieve it in person at the consulate, despite the consulate being hundreds of miles from where she lives. Without reading the actual grounds of rejection, you cannot respond to them with precision. That fact became the first argument in the memorandum. Quick pause here. If you have received a preavviso di rigetto and you are trying to figure out what to do, the article on this case, linked in the description, walks through the full structure of the response. That article is free, and it is more detailed than what I can cover in this video. The memorandum was structured in layers. Each argument was designed to hold independently, even if the ones before it were rejected. Argument 1. Suspension pending the Supreme Court. The central request was not recognition of the citizenship, it was patience. The Sezioni Unite had already held the oral hearing. A ruling on the exact legal question blocking this application was imminent. Issuing a final rejection under those conditions before the Supreme Court has spoken would be contrary to the constitutional principles of sound administration and procedural economy under Article 97 of the Italian Constitution. If the Supreme Court then holds, as the case law trend suggests, that automatic citizenship loss for cohabiting minors was never the correct reading of the statute, the consulate would have rejected an application based on a premise the highest court has since repudiated. The applicant would then be forced into litigation to vindicate a right that could have been recognized without it. The ask is suspend the file and wait. Argument number 2, retroactive application of the 2024 circular. The application was filed in 2022. The circular that introduced the current restrictive interpretation was issued in October 2024, more than 2 years later. At the time of filing, the administrative practice and the case law were materially different. The applicant has spent years and significant resources gathering documentation based on a reasonable understanding of the law as it then stood. A new interpretative framework cannot be applied retroactively to an application filed under different conditions without violating the principle of legitimate expectation or legittimo affidamento, which is protected under both Italian constitutional law and European Union law. Argument number 3, unequal treatment across consulates. The memorandum attached documentary evidence, a letter from another Italian consulate, showing that legal identical cases were being handled differently. Some consulates had suspended their minor issue files, others were moving to reject. Italian citizenship is a diritto soggettivo perfetto, a fundamental subjective right. The Italian Supreme Court has consistently held that this kind of right cannot be subject to administrative discretion. A right that produces different outcomes based on which consulate a person is geographically assigned to is structurally incoherent, and it violates both Article 3 of the Constitution, equal protection, and Article 97, impartiality of public administration. Argument number 4, the reacquisition question anticipated. In cases like this, consulates sometimes raise a follow-up objection. Even if the grandfather lost his citizenship as a minor, couldn't he have formally reacquired it later as an adult? If he could have but didn't, isn't the chain broken regardless? The memorandum addressed this before it could be raised. The grandfather was born in the United States, was a US citizen by birth, and spent his entire life in the United States. He had no practical need to reacquire a citizenship that had never functioned in his daily life. His failure to do so is not the evidence of an abandonment. It is the entirely expected condition of a second-generation immigrant. Moreover, any serious archival research into potential reacquisition acts would require months of investigation, far beyond what a 10-day procedural window allows. Argument number 5, the maternal line observation. The final argument was different in nature. Not a rebuttal of the consulate's position, but a legal observation about what the current framework produces. Read together, the minor issue barrier on the paternal side and the separate obstacles on the maternal side create a situation where the citizenship right is effectively unreachable through no fault of the applicant. That cannot reflect the legislator intent. This was framed as a structural observation and paired with a specific legal request to preserve the original 2022 filing date. Under the transitional provisions of Law 74, that date determines which legal regime governs the case, and it may be the most important fact in the file. Following submission of the memorandum, the consulate replied in writing. Rather than issuing a final rejection, the consulate confirmed that it was suspending the file. It committed to waiting for the Sezioni Unite ruling before taking any further action. Let me be precise about what that means and what it does not mean. It is not an approval. The application has not been accepted. The case remains open. The consulate can still reject after the Supreme Court rules, depending on the ruling's content. But within those limits, the result is significant. The preavviso di rigetto, by its own logic, is a warning. The administration has decided that it intends to reject your application. For a consulate that had already reached that conclusion, to then choose to suspend, to step back from a decision it had effectively already made, is not a routine outcome. The memorandum gave the officer genuine legal cause to reconsider. The arguments were sufficient to make proceeding to a final rejection before the Supreme Court has spoken look premature and potentially indefensible. What it does demonstrate is that the arguments worked. A non-response or a letter that merely restated the facts would not have produced this result. Since Law 74/2025 came into force in March 2025, the 10-day response window has acquired a weight it did not previously carry. For applicants who entered the consular pipeline before March 28, 2025, the administrative phase is no longer simply a procedural step. It may be the last moment at which the case can be resolved under the legal conditions the applicant originally counted on. A final rejection, issued now, does not merely close the administrative file. It resets the clock under a legal framework that has changed substantially since the application was filed, and that transition carries its own set of consequences. The 10-day window is where that outcome can still be avoided. What is filed there, the quality of the arguments, the documents attached, the legal observation made, builds a record that will govern everything that follows, in court and out of it. Now, let me summarize. The case involved a minor issue configuration, paternal great-grandfather naturalized, grandfather a young minor at the time. Application filed in 2022, preavviso di rigetto issued in mid-2026. The memorandum argued 5 points. The Supreme Court is about to rule, suspend and wait. The 2024 circular cannot be applied retroactively to a 2022 application. 3. Consulates are handling identical cases differently. This is an equal protection problem. 4th, the absence of reacquisition documentation is not evidence of abandonment. And last point, the current framework creates an outcome where the right is unreachable. The original filing date must be preserved. The consulate suspended the file. If you have received preavviso di rigetto in a minor issue case, the structure of what I have just described is a starting point, not a template. Every case turns out on its own facts, its own documentation, and the specific arguments that can be sustained on those facts. The full case study with a reconstruction of each argument is in the article linked in the description below. And one more thing. This case was about the minor issue, where the block is in the citizenship chain itself. But there is a separate category of cases where the block is not in the chain, but in the documentation. Original records that do not exist, vital records that were destroyed, or ancestry that passed through the maternal line before 1948. That is a different problem, and it requires a different approach. It is the subject of my next video. See you there!